Said nothing about
I've known Mr.
charges.
Johnson a while. And what?
He never said anything about adding charges on her or nothing at all. That's not true.
See, here's what
I didn't.
I'm a bit concerned about, because now you're going to try to overtalk me. Go ahead.
This case starts quietly, but the tension is already boiling. We have a defendant who no longer trusts her own attorney, a judge who's seen this pattern before, and a decision that could mean walking away clean or facing multiple felony charges. At the center of it all, a breakdown in trust and a courtroom that's running out of patience.
People versus Martina Smith.
The water assistant prosecutor. People.
Good afternoon. May it please this honorable court, Kareem Johnson, on behalf of Martina Smith, who's approaching to my immediate right.
Your name?
Martina Smith.
All right. And what are we doing?
Your Honor, the defense is requesting an adjournment in this matter. There's been a breakdown in the relationship between me and Ms. Smith. She is seeking to retain private counsel.
Didn't she, other than the public defender, didn't she have an attorney before you? Or no?
No.
Okay. Maybe I'm thinking of a different case. All right. Ma'am, what seems to be the problem?
I just don't. I don't feel comfortable.
I don't know what that means.
Well,
Your Honor, she believes that I am working with the prosecution. I've tried to explain to her.
Excuse me? Oh, no, go ahead. I want to hear this.
I've explained to her that under Michigan's R&O statute, there are 7 different ways that you can obstruct an officer, including just talking back or ignoring the officer. We've had an agreement for HIDA. I thought we had that agreement worked out. She had me speak to an individual who I believe was her father, who indicated that he was a paralegal, and gave me his MDOC number and instructed me to actually hold the exam and let you bind it over. I refused to do that because I believe the prosecution would be seeking to add an additional at least 4 counts of R&O for the other officers that were there. And I told him that what I would do is I would ask for an adjournment, because having additional charges added plus walking away from an agreement where she would have no record, she'd be in 25, so she needs the prosecutor's consent for HITA. I felt it was best for her to just get somebody that they feel more comfortable.
Well, okay, so first of all,
you never said nothing about
I've known
the
Mr.
charges.
Johnson a while. And what?
He never said anything about adding charges on her or nothing at all. That's not true.
See, here's what
I didn't.
I'm a bit concerned about, because now you're going to try to overtalk me. Go ahead. I'll wait. You done? Are you done? Yeah. So first of all, I think, because I've watched this attorney in my courtroom on various occasions doing things. And I don't know how he stands there and not take offense when you're saying he's working with the prosecution and forsaking his client. Because this man would never do that. Ever. I mean, I that's what I just find kind of just crazy. And if he really thought it was in your best interest to have the exam, there is not a doubt in my mind he'd hold the exam. So that's the first thing. And I was right. This is now the second attorney. Because, as my staff would remind me, I was looking for the paperwork. you had Mr. Elmer before. And you basically had that same complaint. You don't get to continue to choose attorneys. So I guess part of the problem is going to be, this is set for preliminary examination. And I understand that part of the reason that counsel is asking for the adjournment is really to save you. I am almost of the mind that you don't want to take his advice. You don't want to do whatever. Let's hold the exam. If you get charges at it, you get charges at it. That's your call. But I'm not removing him from the case. So now what do you want to do? Because we're not going to play this game. Ma'am.
Your Honor, may I?
Yes, sir.
Because of the conversation that I've had with her father, I'd humbly ask the court, if the court's not going to remove me, to just grant a brief adjournment. I've never asked this court to remove me from a case ever.
I know.
But we have somebody who has not looked at the body camera footage, advising his daughter on what to do in a criminal case in which she could walk away with multiple felonies. So I understand the court's frustration. I understand the court wants to move in the docket, but this is not her request. I am asking for, at the very least, an adjournment in this matter. So ultimately, she can have counsel that they feel confident in and make a decision that is not going to negatively affect her.
Well, people have a position regarding adjournment.
We certainly no position regarding her counsel. People do not object to an adjournment, Your Honor. People release the witnesses because we were under the impression that an agreement had been reached, and then that fell apart. So people certainly could get the officers back if the court orders to do that, but under the circumstances, we would not object to an adjournment.
I'll grant the adjournment. I can give you, because it's got to go before me, I can give you next week or the 13th, I think is.
What day next week, Your Honor?
The 30th. It'd be Tuesday next week.
That's fine, Your Honor.
That'll work.
Yes, sir.
Preliminary examination in this matter will be adjourned December 30th, 2026. 9 a.m. That's at 12 noon. That's before me.
Yes, sir, Your Honor.
Ma'am, I'm just going to give you a fair warning, and I mean it. I'm not playing this game with you and the attorneys. Either you're going to listen to them or you're going to have an exam, and then the chips are going to fall where they may. If there are other charges and other things added, that's just going to be too bad for you. But if you think that man sitting next to you isn't trying to save you and put you in the best possible position, well, that's your fault. Because apparently with your law degree, and whoever else with their law degree knows more than he does. Bond will continue.
Thank you, Your Honor.
Hit my door. No, she hit my door. Huh? It was soft? No, it wasn't. I heard it. What are you trying to say, her? No, okay. That's fine. I'm not going to make you chase her down. I'm just going to. You do the same. Happy holidays. Okay, in the Christmas spirit, I'm going to let it go. But then that's it. Somebody else do something. That's it. I'm not even looking for your suggestion. Just gonna be an order. Court calls the case, People versus Nathaniel Bryce.
People?
Deputy Judge Tom Lustig on behalf of Mr. Bryce.
Your name, sir?
Nathaniel Bryce.
Thank you. Is this going to be as complicated as the last case?
No, Your Honor, I expect a waiver.
Oh.
Her expectations will be met, Your Honor.
All right. So he's waiving.
He is.
Sir, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right.
We do, Your Honor. In exchange for this waiver, there will be an offer available to the defendant to plead guilty to count 1, attempting, resisting, or assaulting a police officer, causing injury, with a dismissal of counts 2 through 4 and sentencing under 5.
That's your understanding also, sir?
That is my understanding.
All right. Defendant is bound over to circuit court on counts 1, 2, with 3 and 4 following. Counsel, you acknowledge receipt of the information and waive it to you.
Yes, I do.
And how does your client plead?
Not guilty.
All right. Defendant pleads not guilty as to all 4 counts. Court will enter that plea. Pre-trial in this matter will be set for
1:30.
February 12, 2026, 1:30 before Judge Slay. And we'll continue.
Thank you.
Thank you. And happy holidays to you.
Same to you. Yes, you are. May I approach in a separate matter, Your Honor?
You may, sir. Do all this stuff myself. Almost had to chase a defendant now. Myself. Court calls the case, People versus James Thompson. What?
What was the name, Your Honor? I'm sorry.
Thompson.
Did you think I was calling your client? No.
Asking office for the people.
Assistant Public Defender Chelsea deals with and on behalf of James Thompson. Please state your name.
James Thompson.
Thank you, sir.
Good afternoon, Your Honor.
Good afternoon, sir.
Your understanding in for APA evidence at this time, people are unable to proceed.
I would move to dismiss.
People being unable to proceed.
This is the moment that matters. Legally, the judge just made it clear, the attorney stays, and this adjournment is the last courtesy. The warning is unmistakable. If this case moves forward to a preliminary exam, prosecutors can add charges and the leverage disappears. The judge isn't defending the lawyer. She's protecting the process. And she's telling the defendant, on the record, that ignoring legal advice has consequences. In the end, the court grants a short delay, keeps bond in place, and sets a firm deadline. No more games. No more resets. And that raises the real question. When a lawyer is trying to save you from yourself, do you listen? If this case shocked you, hit like, share your thoughts below, and subscribe for more courtroom breakdowns.